Termination of employment due to loss of trust and confidence. Legal grounds and procedures. What is loss of trust and confidence? Loss of trust and confidence is a valid ground for termination when an employee breaches the employer's trust in a manner that affects the business. What is the legal basis of loss of trust and confidence? Under Article 97 of the Labor Code, an employer may terminate an employee for fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. Now, who can be terminated based on loss of trust and confidence? There are two classifications. Number one, managerial employees. These are employees whose roles are primarily vested with trust due to their decision-making responsibilities and authority over company operations. The second classification, rank and file employees, particularly those who handle confidential information, financial matters, or property, even if they are not managerial employees. These employees are often referred to as cashiers, salesmen, auditors, property custodians, or bank tellers. Now, what are the key requirements for a valid dismissal or based on loss of trust and confidence? Of course, number one, the employee should hold a position of trust. Number two, the act that caused loss of trust is work-related. Number three, the loss of trust is based on substantial evidence. And number four, termination follows due process. What are the elements of due process in termination based on loss of trust and confidence? This is also the same process in all kinds of termination. You have the two notice rule. Number one, you have to serve a notice to explain. The employer must notify the employee of the specific allegations. In between, the employee must be given an opportunity to be heard. The employee must have a chance to defend himself in an administrative hearing or conference. And finally, the so-called second notice, which is the final notice of termination or notice of decision. If found guilty, a formal termination notice must be issued. Now, when we talk about loss of trust and confidence, we usually refer to the commission of theft, fraud, or dishonesty. We also talk about unauthorized transactions. It can also refer to gross negligence in handling company funds or assets, especially if you are entrusted with custody of funds, monies, and it can also be committed through breach of confidentiality. Some cases decided by the Supreme Court, it is said that the act must be work-related and must be of serious nature. In other cases, the court ruled that mere allegations of distrust are not enough. Employees cannot be dismissed arbitrarily or based on mere suspicion. In other words, you should be able to prove by substantial evidence that the employee committed those particular acts leading to loss of trust and confidence. Now, what are the key takeaways? Loss of trust and confidence is a legal ground for dismissal only if properly substantiated. As mentioned, it should be based on substantial evidence. The facts should be duly proven. Due process must always be followed. And to be on the safe side, before you resort to loss of trust and confidence as a valid ground for dismissal, always seek legal advice. Thank you very much and have a nice day.